James Mukhwana amewasilishwa mahakamani kuhusiana na kifo cha mwanablogu Albert Ojwang. Afisa huyo wa polisi ndiye aliyekuwa na funguo za seli ambapo Ojwang alikuwa amezuiliwa. IPOA inasema kuwa Mukhwana akiachiliwa anaweza kuhitilafiana na uchunguzi. Huku haya yakijiri, jamaa anayehusika na kuzimwa kwa kamera za CCTV katika kituo cha Central pia amekamatwa. Tusikilize yanayojiri.
The police have a blue code of silence.
I'm talking about specifically on this matter. Key police are involved. I'm talking about. I'm not saying the entire national.
I'm asking.
Yes.
Because this is an affirmment.
Yes.
And it's a very serious affirmment.
Yes.
When the whole National Police Service is being said that they have a blue code.
Council, please silence. Do not mislead the court. There is no in my affirmation. We have indicated the whole National Police Service.
Where is that document, that code? The blue code. Have you attached it? A code is like this criminal procedure code that exists. And that is why I'm asking a very hard question to you. You have alleged that there is a blue code of silence.
Yes.
And you have put that it is an organized offense, according to that paragraph, and all police officers have agreed to be quiet.
You are misleading the court.
Explain. You explain.
No, it's not.
I might be wrong.
Yes, you're actually wrong because that's not what my question.
Allow me to interject. I think counsel needs to focus on the paragraph in question. He has repeatedly asked the question and it has been answered. Now he is attempting to answer it, or rather to lead the witness in the manner in which he wants the witness to respond. Let him attack the paragraph specifically. The witness, the officer has stated clearly that he is specifically dealing with this case. If counsel knows of any other code, then he can do that in his submissions. But the witness has stated it specific to this particular issue. So let him avoid putting words in his.
I'm very specific to this case. I'm not talking of any other traffic offenses or sexual offenses. In this case, it is your evidence that the National Police Service has taken an oath called the Blue Code of Silence.
No. Still reiterating objection. He has not stated anywhere.
Yes.
He has not referred to the National Police Service. Let's be clear, that is a serious assertion.
Your Honor, the paragraph starts in paragraph 32 that moreover, because key persons involved are police officers, wielding police powers, who from preliminary investigations have engaged in a web of complex cover-up, employing the Blue Code of Silence. He has started by saying it's a multiplicity of police officers, wielding power, and that they're using the Blue Code of Silence. And that's what I'm putting him to task. Does he have evidence that from the Inspector General downwards, by rank and by name, anybody is doing that Blue Code of Silence? Simple.
I didn't just answer the question, but I think it was not answered well to you. Maybe you can frame it in a different way.
I'll come back. I'll come back. Let's go to paragraph 33.
Yes, Your Honor.
What are you saying in paragraph 33?
The matter has elicited considerable public anger and outrage, as made apparent by demonstrations held over the matter. Therefore, the safety and security of the respondent may be imperiled if he is released on bail.
Read paragraph 34.
The court can take judicial notice of the fact that this matter is of great public interest. There is an outcry from Kenyans from all walks of life, including the Senate, the National Assembly, and even the President of the Republic.
So, this matter has been discussed in the Senate, true?
Yes.
This matter has been discussed in the National Assembly.
Yes.
The President of the Republic of Kenya has also talked about this matter.
Yes.
Go to paragraph 3. Tell the court your mandate and your powers under paragraph 3.
IPOA is mandated to investigate any death or serious injury, including death or serious injury while in police custody, which are the result of police action or were caused by members of the service while on duty.
Confirm that IPOA is an independent constitution.
Yes.
It is a constitutional entity that does not take directions other than from the DPP.
We don't take direction from DPP.
When you forward your file, the DPP either approves or recommends further directions.
Yes.
That is the only office that you can deal with. Is it your evidence that you are not acting out of your mandate, but you are acting out of the discussion in Parliament, Senate, and the comment by His Excellency the President?
We are acting as per our mandate in section 6, 7, and 5.
Is that paragraph supposed to be there? That's what I'm asking. Does it add any value?
What we wanted the court to take judicial notice of what is happening in this matter.
Well, almost the last paragraph. Paragraph 36.
Yes, sir.
What does it say?
He was arrested on 12th of June 2025 and placed in custody at Capitol Hill Police Station, and he has been brought to court in accordance with the provision of Article 49(1)(f) of the Constitution.
When was he arrested?
Yesterday.
Kindly, did he attempt to run away at the time of arrest?
No.
Where exactly was he arrested?
At ACK Annex Gardens entrance.
Which is the headquarters offices of where?
IPOA.
Was he brought under handcuffs or he walked himself there?
Allow me to explain this.
Yes, that's it.
The previous day when he came to record his statement,
Yes.
we were supposed to detain him actually, but because of the counsel that accompanied him, requested that we allow them, they go and he comes back to the response the following day. So we agreed on a time at 8 a.m., which he never honored. So by the time he got a wind that IPO have now started want to arrest him, so he brought himself without being arrested.
Is there anywhere in your avowment saying that what you agreed was not complied with?
I'm under oath and I've stated the truth to the court.
Is there anything showing what time you required it?
He was present, she decided, okay, can confirm.
And you confirm that he came himself?
He was with an old man.
With a
relative, I think.
A relative. And you locked him?
We arrested him. Because he got a wind.
That's what I'm saying.
He brought himself because he got a wind that we want to arrest him.
You want the court to believe that IPOA's information, people can leak that information?
The same was...
That's scaring to Kenyans.
No.
If somebody can know what IPOA intends to do.
We publicly stated in the parliament that 3 arrests will be made.
You give the names?
I don't recall, because the chairman was making the statement. I don't recall whether he gave the names. Probably the document that he gave had the names.
Do you have a problem for the respondent to be released on bail?
Yes, I do.
I'm officially going to make an application for him to be released on bail. Why will you oppose bail?
Based on what I've stated in my affidavit.
I have taken you slowly of why you need him, and you have not proved any reason of him being with you physically.
That is your interpretation of my answers.
Very well. We can now submit over. We are through with it, unless the state wants to re-examine their witness.
Nothing, Your Honor.
You know, we've not. There's an application I'm making now.
Oh, you're not yet.
No, we are not yet.
All right.
You know, the respondent wishes to make an application for him to be released on bail and reasonable bond terms. On the following basis, there has not been established any compelling reasons to warrant the respondent to be detained for 21 days. The respondent willingly submitted to the authorities when summoned. The respondent is a serving police officer. And the government has all the records. You know, you can discharge Jibril because we'll take long to make our submissions.
All right. So
Unless
we are done with it?
we're done with it.
I think you can now leave.
Thank you.
Thank you.
Yes.
You know, there has not been any material placed before this court to show an attempt to interfere with the investigations. My other brothers and sisters here will deal with the authorities that demand for that. You know, this detention of 21 days is a plea detention. Where the liberty and the freedom of the respondent the purpose of bail and bond is to ensure the attendance of the respondent before this court. Is plea detention the only option available? To the state, you know, that has been dealt by in the case of Oscar Sudi by then Justice Professor Ngugi. My associate should deliver that authority and put the citations very clearly. The state cannot now say it cannot prevent interference with witnesses. The Republic of Kenya is not a banana country. That the state is scared of a citizen being out. The mandate of the government of Kenya is to ensure everybody complies with the law. So the government cannot come to court that we fear he's going to interfere. That is a banana country that will tell people that we fear an individual is likely to interfere. If the respondent interferes, the bond terms will be cancelled and the state will come to court. To show that he has failed to comply with the court orders. Your Honor, you are aware of the celebrated case of Michael Oyamo at the Court of Appeal, where the Court of Appeal was very emphatic that the court has jurisdiction, has power to impose conditions. And that is why we are seeking that the court imposes conditions of bail and bond. Your Honor, the fear of the state is a fear of a police constable. We urge the court to take judicial notice that people wielding massive powers in form of cabinet secretaries, sitting governors, heads of state at the ICC, when Kenyan leaders were taken to the ICC, they were released on bail. So that fear Justice Kuril has dealt with that fear in the celebrated case of Dwight Sagare. The state must show by materials that the fear they are having is not mere apprehension. You know, this respondent can be released on cash bail, and the court orders he does not step. He does not step near Central Police Station. His parents are here, his relatives are here. He'll be confined to his home area until when the DPP decides to charge. Your Honor, we urge the court to stand firm and treat the respondent the same way all other accused people or respondents appear before you, so that it does not look that there is discrimination and there are two parallel laws for the
to believe that the suspect has been involved in an offense carrying a custodial sentence, and Your Honor, I stress on the word and, being conjunctively, there is a danger to abscond, commit further serious offenses, or if released, the individual will not be in the interest of justice. Your Honor has had the benefit of hearing the evidence and the testimony of the deponent of the affidavit. Your Honor, there is no tangible evidence that has been submitted before this court other than the mere apprehension that the respondent is likely to interfere with investigations. Your Honor, the deponent has gone on further to remind us, and he does so in his affidavit and the application, there are already preliminary investigations which have realized some certain facts. Those facts are not within the court's knowledge. And there's not even a single attempt to inform us why, in the application of denying someone liberty, the information gathered is not before this honorable court. Your Honor, those are my humble submissions insofar as the application for bail is concerned. Okay. And before, Your Honor, I sit down, I need to further point out to this honorable court that the application Your Honor, if you look at prayer number 2 of that application, which is the substantive prayer, asks that this court, that the respondent be detained at Capitol Hill Police Station or any other police station within the Republic of Kenya as the investigations may dictate for a period of 21 working days. Your Honor, one can, if you are not keen enough, one will miss the mischief in that prayer. And the mischief is in the wording of 21 working days. Your Honor, will note that this application has been brought under the ambits of Section 36A of the Criminal Procedure Code, which is a written statute. And as we all know, as lawyers and even students of the law in this courtroom, that statutes have their own ways of interpretation.
Yes.
And, Your Honor, to discourage this sort of mischief, the Parliament, in its own wisdom, brought into force the Interpretation of General Provisions Act. And, Your Honor, Section 57D
Serial number?
Section 57D.
Okay.
It states that where an act or proceeding is directed or allowed to be done or taken within any time not exceeding 6 days, excluded days shall not be reckoned in the computation of time. The excluded days are Sundays and public holidays. That is if the prayer or any request is made where computation of time is required for less than 6 days. You're not asking for 21 working days. That is well over the 6 days which are provided. And Your Honor will note that this question was addressed in the case of Longinus Oroni Murunga versus David Masika Matumbo, Civil Appeal number 319 of 2013, in the Court of Appeal at Eldoret. And Your Honor, paragraph 12 of that decision goes on to explain, so that for the benefit of the applicant, they do not perhaps wish to proceed with this mistake in another case, that the section 57 is very clear, and in fact it goes in tandem with Article 259(6) of the Constitution in terms of computation of time. Therefore, it is my submission that the application as framed, we are all aware that we are bound by our pleadings. That the orders cannot be granted. As such, the application is incompetent. And the respondent should be released forthwith. That's all, Your Honor.
All right.
Your Honor, may I?
Oh, you want to say something?
Yes, Your Honor, let me say something.
Can you remind me your name?
Yes, Ms. Sophie Nekesa, Your Honor.
Okay.
I will be very brief, Your Honor. I want to deal with the applicant's reasons for detention. As defined from paragraphs 31, from paragraphs 24 up to paragraph 31. Your Honor, those are the reasons the applicant has put forth to this court as for the reasons for the need to detain the respondent herein. Your Honor, my submission is that all those reasons listed from paragraph 24 to paragraph 31, for all those reasons that they have listed, they do not need the respondent for that. Your Honor, this matter, or rather my submissions, are based on the authority which I have served the DPP, Betty Jemtai. This is a miscellaneous criminal application. Betty Jemtai Kimeyo versus the Republic. This is a miscellaneous criminal application number 26 of 2018. Your Honor, there are three things, or rather three important action points that I wish to address from this authority.
Yes.
Miscellaneous criminal application number 26 of 2018. Betty Jemtai here. Please. So, Your Honor, paragraph 7 of that authority, the court is saying the respondent can be detained based on available evidence. Available evidence are the wordings of that paragraph, Your Honor. It has already been shown from the supporting affidavit of the applicant, no evidence has been shown to this court, and therefore they are mere averments. it has not been shown, Your Honor, paragraph 9 of that authority, the reason as to why the respondents might be detained further. The prosecution needs to show that the suspect is a flight risk or is likely to escape or is likely to interfere with the witnesses. Your Honor, even from the supporting affidavit of the applicants, they have not averred to that effect. There is nowhere the applicant is saying the respondent is a flight risk or is likely to escape. And number one reason why the respondent is not a flight risk, why he is not likely to escape, and why they did not put that in their supporting affidavit is because the respondent is a serving police officer, Your Honor. He cannot escape and leave his job. That is what he does for a living. That is what sustains him and his family. There are averments to the effect that the respondent might interfere with witnesses. Your Honor, paragraph 3 of the supporting affidavit of the applicant. The applicant says they have already interrogated some witnesses. So when at paragraph 30 they say they will already interfere with witnesses, we are wondering if who are these witnesses that are yet to be interrogated? Because at one point they will interfere with the witnesses, at another point we have interrogated the witnesses. So where is the truth? If anything, Your Honor, this is a police corporal. Constable, apologies, Your Honor, is a police constable. It cannot be true when the applicant says he is a police officer. That is paragraph 32 of the supporting affidavit. It cannot be said that the police officer wields police powers. A police constable, Your Honor, is not capable of wielding any police powers in the context of these investigations. So, Your Honor, if we read the supporting affidavit from paragraph 15 all the way to